So we're just about ready to get started now. I'll pass it on to our Director of Estate Solutions, Sarah Hillier. Take it away, Sarah.
Thanks very much, Carrie. I appreciate your help facilitating this important webinar. I'm very actually excited to talk about this topic because I feel like it's a sometimes misunderstood and a bit technical. So I'm glad to be able to share with you some information about it. So welcome everyone. Here's a quick agenda of what we're going to be covering today, which is of course all about probate and sort of how to navigate the probate process and some quick tips for saving time and energy through the probate process. So real quick, just a little bit about myself. I've been in the estate and trust field for many years and have earned a few professional designations in the space. Mainly, my goal is always to make these topics approachable, easy to digest, and of course, personally, I've been there myself as well. And really, my goal today is to arm you with some information and give you some practical guidance. Okay, a little bit about ClearEstate so that you know who we are, what we're all about, why we host these free webinars. Essentially, ClearEstate was founded when Alex, one of our co-founders, after going to administer his own mom's estate and finding the process to be antiquated and challenging and in need of a sort of shake up and a different way of doing things. He sketched out a plan to solve the very real problem that exists where folks really don't have a lot of options in terms of guidance and support in this area, and particularly not technology-based or comprehensive guidance in this area. So he basically created ClearEstate with a vision of assembling a team of engineers to develop technology to make the processes super efficient, with a team of subject matter experts to actually support families with a human touch and make sure that we're getting it right. Okay. Now for today, the learning outcomes really, we want you to learn all about probate and what it exactly it is, how to navigate it and save time and energy, as well as where to go for help. Okay. Now, before I dive right in, I just want to say that we are going to leave a significant amount of time at the end for questions. So as Carrie mentioned, like, please feel free to add your questions in the Q&A section or questions section. And try not to put them in the chat because they might be missed if they're in the chat. So right into it, all about probate, which technically is formally referred to as certificate of appointment of a state trustee with or without a will. That title is very long, so it is more commonly referred to still as probate, which is what it used to be referred to as. And quite simply put, this is a judicial process whereby the will, if there is a will, and the estate representative's authority over the estate is actually legally verified. Okay. I'm going to go into more detail momentarily. So why does probate actually need to be done? Well, essentially, the question becomes, when the executor goes to actually deal with the assets of the estate, what parties are they going to have to deal with, and what are those parties going to require in order to accept their authority? Okay. So more often than not, it's needed because the third parties who are actually holding the assets or safeguarding the assets, like financial institutions, for example, are going to require more than just a copy of a will in order to accept the instructions of the executor. Okay. So that is why probate is generally necessary in an estate settlement. And we'll talk a little bit more in a second about, when is probate not necessary? When is it not needed? Now, this ties kind of into the first question. Who does probate actually protect? So the obvious answer is, of course, the third parties, because if they refuse to act on instructions until they have probate in hand, then this is protecting the third party, that they in fact are dealing with the correct legal representative of the estate, and it was the valid last will and testament of the deceased, right? So it's really to protect a financial institution, for example, from taking an executor's word for it, if you will, and distributing the deceased asset to that individual, and then later having someone else come forward with, you know, another will that says, no, I'm the legal executor of the estate, or any other disputes like that. The financial institutions do not want to be responsible, and third parties do not want to be responsible for that determination and that responsibility. Okay. Now, the other less obvious party that it actually protects is the executor themselves, because it's the only way to legally validate your authority as the estate representative. So it's designed to, you know, protect you from a scenario where you decide not to get probate, and then later on there's questions as to what you've done and how you did it and whether you should have done it. It makes it a little bit more difficult to handle that when probate actually wasn't granted in your favor. Okay. And does every estate need to go through probate? This is a super common question. And the answer is no, not every estate needs to go through probate. And we're going to talk a little bit more about the specific assets that are included typically, or need to be probated and don't need to be probated in a minute. But essentially, if there are no assets in a deceased person's estate where the third parties are going to require probate, then technically probate is not necessary in order to complete the estate settlement. Okay. When do I start the process? So there's no like exact answer to this, but really the reality is it's as quickly as possible, as quickly as is practical, ideally. And we'll talk a little bit more about timelines in a minute, but it can be a quite involved process. And so the sooner you can start it, the better, keeping in mind that there are limitations to what an executor can do. Even though they have the will that appoints them, there are going to be certain limitations to what they can do until the probate process is actually complete. Okay, so ideally as quickly as possible. I just want to make sure here that I cover the questions that were also submitted. We're going to do that throughout the presentation as well as at the end. Now, where you think, you know, probate is relatively straightforward, and it's, you know, where you think the estate circumstances are relatively straightforward, you know, it's still not necessarily easy to navigate the probate process. Okay, so lots of people ask, you know, does a lawyer need to be involved, right? And the answer is technically no. A lawyer does not need to be involved to go through the probate process. However, it is highly specialized expertise, and we are talking about legal forms that are submitted to court. And they're kind of, I'll say, designed by lawyers with the intention of lawyers completing them. So they're not necessarily it's not necessarily the easiest process to navigate, right? But you don't necessarily need a lawyer. But what I would recommend is that you consider the options available for you in terms of support, because to the point that's here, it is critical to a smooth estate settlement that the probate process is initiated quickly and done correctly. And obviously with some professional guidance and support, your chances of having things go smoothly are much higher than when you're trying to take on things on your own. Okay. The other thing is, you know, most people, it may be and hopefully it's one of only a few times they may deal with this in their life, maybe only one time. And so you're going to be dealing with things you're not familiar with naturally, right? And that's the part that, you know, you may want to seek professional guidance and assistance to make sure that you're actually doing things correctly, and that when you do submit your application, you're not going to get into trouble because you filled something out incorrectly, and then the court process takes longer and there's questions that you have to address. So ideally, you do consider professional guidance. Okay. Can beneficiaries see the will before probate? Beneficiaries can see the will before probate if you know, they ask for it and an executor wishes to provide it to them. When in the application process, the executor is actually required to serve the beneficiaries notice, which includes if they're residual beneficiary, which means they're receiving a share of the balance of the estate. They're going to receive a complete copy of the will. And that's a requirement in the Ontario probate process. Okay. So how long does probate take? This can vary significantly depending on the actual jurisdiction. So of course, we're talking about Ontario today, but even the specific courthouse where you would apply in smaller municipalities, this tends to be a little bit of a quicker process. Larger municipalities like Toronto tends to take longer because of volumes. COVID has delayed the process somewhat as well. But essentially, you know, you have your assessment phase where you're figuring out the information you need for the probate application, which can take, you know, as little as a few days if the deceased was extremely prepared and the executor is well aware of all the information needed, to several months if there's a lot of kind of loose ends to figure out, like accounts over here and over there, and locating things and accessing information. That can take longer. But once all the information is collected and the probate application is actually prepared and submitted to the court, from that point on, it can be anywhere from weeks, days to weeks, sometimes months, a huge range of how quickly a probate application can actually be completed. Okay. We'll talk a little bit in a sec about simplified or small estate applications. But we did get this question, can the process actually be accelerated? So definitely, like I just referred to, if the deceased is very organized, that's obviously your first way to help accelerate the process when that time comes. The second way, of course, is to engage the right, you know, professional support, particularly, you know, like ClearEstate, we have a super efficient process, so we can actually prepare probate applications very quickly, providing we have the information needed to do so. The other question we get about accelerating the process is around, you know, if the application is submitted, one of the big things that may be happening in the estate settlement is the sale of real property. And what happens is you can't actually transfer the title of real property until you have the grant of probate. But you can ask for that process, the probate application, to be expedited if you actually have a purchase and sale agreement in place. So it's possible to actually accelerate the application even once it's submitted, but there has to be, you know, sufficient grounds for them to accelerate it. So I get the question often, you know, like everything seems simple, like, can I just do it and, you know, save money for the estate? And like I said, like you can attempt to do that. The question becomes, are you comfortable doing everything that's involved without professional, you know, assistance, right? And I think that's something you have to think about quite carefully as an executor, because of course, there is a significant amount of liability on your shoulders in carrying out your role. Okay. Some people also ask, how does the probate process start? I'm going to walk through the actual steps that you need in order to complete the probate process in a minute. And also somebody asked, you know, how do you know when probate is complete? And essentially that is You get the grant of probate or the actual certificate of appointment of a state trustee back from the court, and it's essentially they've stamped on top of the original will their certificate, and that is your actual proof that you've completed probate and you can now go and properly deal with the estate. So here we're going to talk about the associated expenses, okay, with probate. So the first thing that you should be aware of is that in Ontario, properly called estate administration tax, but also referred to as probate fees, it's calculated at $15 for every $1,000 or part thereof, so it's rounded up, of the fair market value of the estate as of date of death that is above $50,000. So in other words, you get a break on the first $50,000, and above $50,000, it's 1.5% of the value of the estate assets as of date of death. Okay, so as an example, for an estate valued at $1 million, the estate administration tax is $14,250. Okay, there is no cap to this. So, obviously, with the more significant the estate is, the more substantial the estate administration tax is. Okay. Now, in Ontario, there actually are no court filing fees per se, so there's not an additional cost to actually submitting the application. However, other than the estate administration tax, of course. However, the other potential expenses that may be associated with applying are, of course, the cost of actually assessing the value of the estate as of date of death, which we'll talk a little bit more about in a second, and as well as the cost of other professionals you might engage, such as lawyers, trust companies, or ClearEstate, for example. This is a calculator that we're going to have available shortly on our website, so that you can actually enter the assets and the real estate related liabilities, and it will actually tell you the amount, it will calculate the amount of probate taxes payable for you. So here we're going to go into a little bit more detail on what assets are subject to probate. Now, when I say subject to probate, I mean that if there's a probate application being submitted to the court, these are the assets that you need to list as part of the estate. Okay. So those assets include any real estate that's held individually, so in the deceased sole name, or if they hold a portion of property tenants in common with others. Okay. So maybe they hold 50% of or 20% of a real property. That 20% forms part of their estate. The value of that is included in the probate application. Okay. The only expense you're allowed to deduct when you're calculating probate fees is actually encumbrances on real estate, like a mortgage, a lien, etc. Okay. Any bank accounts that are held in the person's individual name also would be included in a probate application. And I use the term joint for convenience here because sometimes there are accounts that are held jointly with others, but those accounts are joint for convenience. So the idea is that the original owner is the true owner and they're just joint for convenience with, say, for example, an adult child who's assisting them with bill payments, et cetera, et cetera. I get this question a lot, like how do you determine if it's joint for convenience or what we refer to as joint with right of survivorship? And unfortunately, it's not often well documented how to do that. So if you have any types of accounts like that, one thing that is important is that it's clarified in writing clearly what the intention is for that account. Is it meant to form a part of your estate, or is it meant truly jointly with the surviving owner? Between spouses, the precedent under the law is that it's joint with right of survivorship, but adult children, the precedent is that it's joint for convenience. Okay, you can imagine there can be quite a bit of issues that arise when it's not clear. Okay. The other thing is individual non-registered investment accounts. Again, that's typically included and is subject to probate. Vehicles and personal effects, also part of probate. And any business interests that you may have, also part of probate. And any registered plans, pension plans, or life insurance where the beneficiary is going to be the estate. So that's because you don't have, you haven't named a designated beneficiary, or you have, but they've predeceased you, it defaults to your estate. So that would form part of your estate and be subject to probate fees. Also, any loans and promissory notes that are owed to you. Okay. The next slide here, we're going to talk a bit about the assets that actually are not subject to probate. Okay, so real estate that's actually held as joint tenants, which is joint with right of survivorship, passes directly to the surviving owner. It does not form part of your estate and therefore is not subject to the probate process. Same idea for bank accounts held joint with right of survivorship, as long as it's clearly documented that it's joint with right of survivorship. Investment accounts, again, held joint with right of survivorship. I also mentioned any eligible assets under a secondary will. In Ontario, there's an estate planning strategy where you create dual wills. So you have two wills that are both valid at once. And the reason you might do that is if you have certain assets that no one is actually going to ask for probate in order for you to deal with, or your executor to deal with, but you also have assets that people are going to ask for probate. So you separate those out, create two wills, one that gets submitted to the probate court and one that doesn't. And there is only a short list of assets that, you know, can be eligible under a secondary will like this. One of them is shares of a privately held company. So if you own your own business and have any type of structure like that, this is something that's commonly considered because the shares of the privately held company can be transferred without probate, providing you have this dual will strategy in place. Also, I'll talk about the real estate exception in a second. Any personal effects, because of course you can transfer those typically without probate unless it's like some super valuable collection or artwork. They may ask for probate. And also any loans that are owing to you or promissory notes, that's something that you could potentially have under a secondary will. Obviously, if you have any such assets of these that are significant, it becomes more important for you to think about that and have that as part of an estate planning discussion. The other asset eligible is actually this next point here, which is real estate that qualifies for the first dealings exemption. The first dealings exemption is very rare these days, but it basically is in Ontario. The land title system was implemented in the late 60s, I believe. And after, essentially, if your property has actually never been transferred on the land title system, it can qualify for a first dealings exemption where probate won't be required to transfer it for that first initial transfer. Now, because that system was implemented quite a while ago, it's very rare for properties to qualify for this exemption, but we do still see this come up sometimes. And sometimes for that reason, people will include this specific asset in a secondary will. Okay. The other things that are not subject to probate are any registered plans with named beneficiaries. There are some exceptions because I'm not going to go into detail, but with RESPs, RDSPs, there's a bit of additional, consideration and planning that has to go into making sure that there's actually a successor to those accounts to avoid your contributions reverting back to your estate. But generally speaking, registered plans with named beneficiaries are not going to form part of your estate, not be subject to probate fees. Okay. Also, same goes for life insurance and pensions with named beneficiaries. Assets held in an inter vivos trust. What is an inter vivos trust, you may ask? Essentially, it's a trust that you establish during your lifetime. There are many different reasons you potentially may do that, which would be for a separate webinar. But essentially, if you transfer assets to this type of trust, upon your passing, those assets won't form part of your estate and won't be subject to probate fees. Okay. The CPP death benefit, sometimes people ask as well, that's not included. That is part of your estate, but it's not included in probate calculations or probate applications. The other thing I'll mention too, just real quickly, is that if you have assets in other jurisdictions outside of Ontario, it's important to take a good look at your estate plan to make sure that your will sufficiently addresses those assets. Do you perhaps need a will in that other jurisdiction? In some cases, it is included in the probate application. In some cases, not, depending on the type of property and the way you've structured your estate plan. So that's an important just note there. Okay, now we're going to actually go through the process of the estates, the probate. Okay, so the first thing you do, locate the original will and safeguard it because you need it for the application. If there is no original will, then the process is very similar with the extra steps of confirming, okay, who should actually be the estate representative and who are the beneficiaries. For both of those, decisions, there is legislation in place to dictate what happens. But I'll just say on that note, without a will, it makes it much more difficult for loved ones to go through the process because they don't have a starting point of a will that actually appoints a legal representative. So there's a lot more work to do to appoint a representative, confirm the beneficiaries of the estate, and move forward from there. Okay. Second part, confirm who all the parties are that are involved and their pertinent details. Identify them basically. So, the deceased, their pertinent details, the executor, their pertinent details, all of the beneficiaries and their pertinent details, and any other third parties that may be involved, like a parent or guardian for a minor, etc. The next step, assess the fair market value of the estate. And in some cases, that's really simple and straightforward. Investment accounts, you can, simply have a statement as of date of death or request a statement as of date of death. However, other assets may be a little bit more work to do to assess the value. Certainly, any stocks of or privately held shares of companies, any real estate, you may want to obtain an a certified appraiser to actually appraise the value of the property. Sometimes people use realtors' opinions of value there as well. And anything that is, specialized, like collectibles or, anything like that, you may require. Even jewelry, lots of times requires a specific appraisal. Sometimes people are surprised that personal effects even matters. However, in the probate process, it is considered part of your assets. And the probate court takes, making sure that executors are filing the correct information more and more seriously. And I'll talk about that a little bit more in one of the final steps in the process. So assessing the fair market value of the estate. From that assessment, you're going to create an inventory of the estate assets and liabilities in order to actually proceed with the application. Okay, you're going to calculate the amount of probate fees that are due based on the calculation that I had just talked about. And then you also need to pay the probate fees when submitting the application. A question that I get very commonly is, what if there's no liquid assets to pay the probate fees at that time? There is a process where you can have a request to the court to delay the payment of probate fees until there's sufficient liquidity in the estate to pay the probate fees. So there's a process for that. And then the court will review it and consider it, and providing there's sufficient grounds, they can accept that. The next step is to serve the beneficiaries. So I talked about that a little bit before. Essentially, you're providing all the residual beneficiaries of the estate with notice that you've actually filed the probate application, or you're filing the probate application, to give them an opportunity to, view the will, as well as a sort of timeline for them to, address any concerns they may have with the inventory. If anything's unexpected or missing, then they can come forward. The next step is to actually prepare the probate application itself, filling it in, carefully to be correct, and filing it with the court along with that check for the probate fees. And then, of course, the court's going to carefully review that, and they're going to potentially come back with questions or concerns or issues, which then would have to be addressed. Hopefully not. And then they're going to grant probate. And that's going to be your proof to go and do your thing as the executor of the estate. The next step is going to be your notice to creditors, which essentially is your part of the process is you're required to advertise to creditors, which basically means that you're giving creditors an opportunity to kind of speak now or forever hold their peace regarding any potential outstanding debts that the deceased had. Okay. And there's the traditional way of doing that is through, a newspaper, a post, an ad in a newspaper. There's more modern ways where you can do it online. We can help you do that, of course. And then there's, after that's done, that's protection for the executor too, I'll mention, right? Because now no one else can come forward later and no one else can come forward later and say that they were a creditor. That's their opportunity to do it then. The final step really is referred to as an estate information return, or EIR. And this is due 180 days after probate is granted. And it's a relatively new requirement that was implemented in Ontario to help the courts be assured that executors were actually providing the correct asset values to the court. So it actually is another separate process, a separate return, separate filing that you submit to the court that confirms the previously submitted values of the assets, or corrects them if corrections are needed. And if there's an adjustment to the probate fees, an increase in the probate fees, that also needs to be paid at that time. Okay, so this is really meant to walk you through the probate process itself. Obviously, there's actually much more to the entire estate settlement process, but we really wanted to focus on the probate process itself today. One relatively new procedure in Ontario is there is a different process for a small estate, and in Ontario, a small estate currently is determined to be 150,000 or below. Okay, so if an estate is below that threshold, it qualifies for the small estate process, which is very similar to this process. You still have to prepare, you still have to have this information, and you still have to prepare and file it. However, it actually, you can do it more quickly because you can submit it via email, and it takes generally around 5 business days. So it's much, much faster than the full probate process. Okay. The other thing that we get asked is when there's no will and you can't confirm the value of the assets, what you would have to do is basically at the same time that you're asking to become the administrator or the estate representative, you're submitting an estimate of the value of the estate to the best of your knowledge, because you're not going to be able to confirm it because people won't release information to you, right? So you just submit an estimate with there's another special request for that, which basically states that you're gonna confirm it within 6 months afterwards, what the actual values of the estate are. Okay, a few quick tips for saving time and energy and expenses. So of course, in advance, review your estate plan very carefully, and specifically to see if there are any efficiencies that can be created with respect to probate and avoiding the probate process, or at least avoiding probate fees in some scenarios. That definitely can be a vast, area of exploration, and it's really important that that's done carefully and looking at your overall estate plan and not just individual specific accounts or assets. Okay. Now, during an estate settlement, there is actually something that you can do. However, it doesn't work in all scenarios. You can actually request that third parties waive their requirement for probate. Okay. Most financial institutions have a threshold where they'll be okay with waiving probate, but there's no universal rule. They all have their own internal policies and procedures. They may waive it and they may not, particularly now that we have the small estate certificate process. They're less likely to waive it, but it is something you can do. They won't advertise that they will consider it, but you can ask. Okay. And finally, of course, at all times, get the right help. Consider alternatives to traditional service providers. Like ClearEstate, of course, we support families with estate settlement and estate planning, and are happy to have these conversations with you about how to make sure that your estate is efficient. Now, just a few key takeaways, and we'll move on to questions. The driving point here that I want to make is that when probate is needed, it takes considerable time, energy, and know-how to do it right. Okay. And you really need to consider what you can do in advance to avoid probate where it makes sense. And I'll also add to set your loved ones up for success in navigating the process when the time comes. Okay. And finally, always seek the right professional support. It's really important that you consider things carefully, and as this is really a specialized area of expertise, it's preferable that you do seek professional guidance. Okay. ClearEstate does offer no obligation free consultations, which are designed to provide some practical guidance for your unique situation. So you'll receive a link afterwards if you're interested in booking a free consultation. We're happy to do that for you. You will receive, as Carrie mentioned in the beginning, a link to the recording of the webinar. And like I said, the Ontario Probate Calculator will be available online soon for use as well. Now, okay, I think Carrie's going to, I think you're going to read off some of the questions, right? That weren't, okay. Perfect.
I will. And we got a ton of really great questions. So hopefully we'll have time to address everything. And just to let everyone know, if we don't happen to get to your question, rest assured we will reach out to see if we can answer your questions further after the webinar. But let's jump right in because we've got lots.
Okay.
So first of all, here's a question. My sister was named the executor. I paid for funeral expenses. How can I get my money back?
Okay, great question. So funeral expenses are absolutely an estate expense. If someone has paid out of pocket for them, then they really should be submitting the invoice, proof of payment for that to the executor with a request for reimbursement. And the executor should be reimbursing that from the estate prior to, of course, calculating the residual balance of the estate. Yeah.
Great, thank you. Next one from someone who sent this in through registration. My dad passed away this past June, and we are so sorry for your loss. I have his will, but the signed will was at the lawyer's office, but it has since closed down, so I can't find the signed will. The will is dated 1979, which is many years ago, so I have no idea what to do.
Okay. Okay, yes. Sorry for your loss as well. It is very tricky to, some jurisdictions have systems and registries. Unfortunately, Ontario does not have any official registries, although there are some digital ones available. There are some online registries available. However, if the will was done in 1979, very likely not on any type of registry. Oftentimes, if the will is actually held by the lawyer, they would have done something with it as they closed their practice. So they would have transferred it into the care of another lawyer that took over. If you can find the path that may have taken that way, you may be able to locate the original will. If it wasn't held with a lawyer and it actually was in your dad's possession, then of course it's a matter of scouring through his personal papers and anywhere where he may have kept it. Anyone who he may have kept it with, or anyone who may have known where he would have kept it. Sometimes it's in a safety deposit box that we never knew about. So that could be one place. But unfortunately, if the original will can't be found, it's very difficult to prove that it exists. So it can be quite a challenge. So hopefully you're able to locate it.
Thank you. We'll move on to the next question. Is there a way to avoid probate? What happens when the estate has a home that is paid for? Does it have to go to probate? And do we have to pay capital gains since it would not be our primary residence?
Okay, so I did talk a little bit about ways to avoid probate. So I think that was probably covered. But the second piece, so I think in this scenario, the beneficiaries, we're talking about capital gains. So to answer the first question, yes, the property will go through the probate process or will be subject to that in order to be able to transfer it from the deceased to the beneficiaries. If the deceased lived at the property, then of course they're eligible for the principal residence exemption up until the time that they passed away. From that point forward, then the beneficiaries who are receiving the property or whomever it may be sold to, now it's any further capital gains from that point forward is going to be your responsibility, unless again it becomes your principal residence and then you're eligible for the principal residence exemption.
Great, thank you. Next question. If my mom plans on leaving me her home and has it in her will, does it make more sense to have my name on her house with her prior to death, or leave it in the will? And this viewer is currently a co-owner of her own home with her husband.
Okay, great question. I love this question. It gets asked a lot. So there's a few important considerations there. Yes, mom can, add you to title as joint tenants on the property. However, that will actually successfully avoid probate if there's no other assets in her estate that require probate. If there is, as long as it's joint with right of survivorship, it can avoid the probate process. But it also presents some exposure for your mom and risk that she may want to think about carefully, because while I'm sure you have nothing but the best of intentions, what that means is that, she loses some control, right? So, she can't choose to do things with the property without you at that point. And it's also accessible to your creditors, in the event of marital breakdown. There's all sorts of considerations there that do create some risk. And then there's the fact of the matter that since it's not your principal residence and you have a principal residence, your share of the property now would not be eligible for the principal residence exemption. Whereas if she owns the whole property, the whole property is eligible. So we're getting into a little bit of tax specific questions, and I want to be clear, we're not attempting to provide tax or legal advice here. All of that is to say you need to review that carefully with your tax advisor to see if it, and of course your mom should review it carefully with her advisors as well.
Great, thanks, Sarah. Next question. How does probate work when the will is contested by the living spouse and wants equalization and support, or wants the whole estate, removing the children as beneficiaries?
Okay, so now we're talking about a situation where under the Family Law Act, the will is being contested because there are some potential there's some potential eligibility under the Family Law Act. So of course, for those of you who aren't aware of what we're referring to here is, generally speaking, you have some obligations to certain dependents or your legally married spouse. So if there's a challenge, it can impact the probate application process, but only if the appointment of the executor is being questioned. If the appointment of the executor is not being questioned, then probate can still occur. However, the contesting has to be sorted out before assets are actually distributed from the estate.
Great, thank you. Next question. Before my mother died, she liquidated all of her assets into a joint bank account with me. There's no property or capital investments. Her will is very simple and that the money is shared with her grandchildren. Do I need to apply for probate?
So if the assets were truly all part of a joint with right of survivorship account, technically probate won't be required, providing it's clear that that account is in fact joint with right of survivorship. You may recall during the presentation I mentioned that accounts that are held jointly with an adult child are not necessarily assumed to be intended as joint with right of survivorship. So if it's not clearly documented that it's joint with right of survivorship, the bank may very well still require probate in order to deal with that account. Okay. And the other thing I'll mention on this too is that when you make an account joint with right of survivorship, you are removing it from your estate and you are giving it to the person that you hold the account jointly with. And the distinction is important because even if you have an expectation that they'll then, let's say, distribute those funds to several other beneficiaries, they don't actually have a legal obligation to do so. They may have a moral obligation, but not a legal one. And when you plan your estate, you want to make sure that those obligations align.
Great, thanks. What if you don't have an executor, but you have a beneficiary and the testator is deceased?
Okay, so this sounds like there may not be a will if there's no executor. So then you would need to go through the probate process for intestate estates where there's no will and appoint an executor or an administrator of the estate to actually carry out the duties. Now, if by saying there's a beneficiary, you mean that it's on a registered plan, for example, or a life insurance policy, you can actually deal with that without going through the probate process. It's just a question of if there's other things in the estate that someone needs to have a formal authority to deal with, then you'd need the probate process.
Thanks. Next question. What are the legalities of evicting the beneficiary out of the house to sell the house, which is the part of the estate? And what is the process?
Yeah. Okay. So I don't think we have time to go into a lot of detail here, but what I'll say is tenants have a lot of rights in Ontario, and that needs to be reviewed and considered very carefully. And they need to be, there's a number of steps. There's a formal process and steps that have to be taken following that formal legal process in order to be successful in these scenarios. So that definitely, I would say, you need professional support and guidance to do.
Okay, great. Next question. If there are two executors in the will and one can't help, what do we do?
Great question. So nobody can be forced to act as an executor. Well, at least no individual can be forced to. Sometimes professionals can be forced to, but individuals can't be forced to if they are, unable or unwilling for whatever reason. They can actually simply resign in their role as executor, and they would do that formally by documenting it in writing. And then the remaining executor or alternate executor would be able to move forward without them.
Okay, thank you. Next question. All of our assets, home, cars, boat, bank accounts, except for RRSPs, were joint. Now that my wife has passed, do I need to probate? I'm the sole heir in the testament and also an executor.
Yeah, so if all the assets were truly held jointly, and the RSPs or RIFs were also with beneficiary designation to the surviving spouse, then probate should not be necessary. It wouldn't be necessary until the death of the surviving spouse, at which time now the assets are held in your individual name, presuming that you don't joint your assets with others. So typically, no, it wouldn't be needed. And this is an example of how you want to look at your estate plan carefully and plan out that at least it's efficient that on the death of the first spouse, probate won't be needed. Otherwise, you may get into a situation where you actually have accounts in your individual name. They're going to need to pass through the formal probate process when you die. And then now your spouse has those assets and they're going to actually pass through the probate process again when they die. So you're going to pay probate fees twice on the same wealth in that scenario.
Thank you. Next question. If the executor has dementia and has a POA, is the process different?
If the executor has dementia, yes, actually. So if an executor is in the middle of acting and then becomes incapacitated, they really can no longer act at that point. And then it becomes important to determine who is going to replace them as the executor of the estate.
Thank you. I'll move on to the next question. If the deceased resided in Quebec, can this be processed in Ontario?
Oh, great question. So probate is generally filed in the jurisdiction where the deceased lived at the time of their passing. Okay. And sorry, Carrie, was it the deceased or the executor that's in Quebec?
The deceased resided in Quebec.
Okay. So technically, the probate process would typically be completed in Quebec. And like I said earlier, depending on what type of assets are held where, particularly with real estate, you may actually need to go through the probate process in the first jurisdiction and then a sort of supplementary probate process in the secondary jurisdiction where they verify the probate from the initial jurisdiction. Important again to plan that out carefully.
And we're actually just about to come up on 1 hour and we still have tons of questions. So maybe we can only do 1 or 2 more. And then of course, we will reach out to anyone who has submitted a question and we will make sure that you get the answers you're looking for. So Sarah, why don't we just do 1 more?
Sure.
Okay. Before death, what can I do to expedite the process? Like what can I do to plan in the planning stage to expedite the process?
Great question. So like, you know, one of the major things that you can do is obviously look at your estate plan as a whole and potentially see where you can develop some efficiencies like I talked about earlier. But also a really big piece is actually compiling all of your pertinent information and documentation that's going to be needed in the estate settlement process by the executor. Okay. And this is something that ClearEstate specifically actually helps clients with because on our platform, when we have our estate planning clients, we create a profile for them. And in that profile, we're going to walk them through all of the various things that they need to sort of store and safe keep for their executor, which does that, you know, that important does the important step of you know, actually having you go through everything with a fine-tooth comb so that you're aware of some things you may have forgotten about or some things that are over here or whatever the case may be. You're aware of actually we help you map out, okay, what does your distribution actually look like? What are your estate expenses going to be? How is this all going to play out when you pass away? So it's going to do two things. It's going to help you understand if any changes or updates are needed to your estate plan. But secondly, it's actually going to help set your loved one up for success when that time comes, because with a few clicks of a button, they'll actually have everything they need to move forward smoothly with the estate settlement.